Hello, everyone, and welcome to this roundtable on non-human rights as a field of academic inquiry, organized by the Forum Decentering the Human at Queen Mary University, London. My name is Eva Berners-Kempers, and I am a postdoctoral researcher at the University of Antwerp in Belgium, also working on non-human rights, but primarily those of animals. And I'm very happy to be your host and host this roundtable today. Thank you all for joining us, and a special thanks also to our distinguished panelists who are all in different ways reshaping how we think about legal rights in relation to non-humans. So before we start with the roundtable, let me begin with a brief introduction of our panelists. Our first speaker is Professor Cesar Rodriguez Garavito, who is professor at clinical law and chair of the Center for Human Rights and Global Justice at NYU School of Law. He's also the founding director of the Earth Rights Research and Action Clinic, the More Than Human Rights, or shortly MOTH program. And he is an Earth Rights and Human Rights scholar in the field lawyer whose work focuses on climate change, international environmental law, indigenous people's rights, and more than human rights, importantly. He's also the editor of the book More Than Human Rights, which was published with New York University Press in 2024. Second, I'm also happy to welcome Dr. Alexis Alvarez Nakagawa, Senior Lecturer in Law and Fellow at the Institute for the Humanities and Social Sciences at Queen Mary University of London. Dr. Alvarez's research interests range from the globalization of Western legal forms and colonial history of international law to emerging trends in human rights and environmental law, including the growing recognition of legal personhood and rights for non-human beings. His work combines insights from philosophy, critical theory, anthropology, and jurisprudence to explore these issues from an interdisciplinary and critical perspective. He's the editor with Professor Kostas Douzinas of Non-Human Rights, Critical Perspectives, published with Edward Elgar in 2024. Last but not least, we also have amongst us Dr. John Adenetire, who is a senior lecturer in the School of Law and a fellow of the Institute of Humanities and Social Sciences. Prior to joining Queen Mary, he was a lecturer in law at the University of Birmingham, and he's also the author, with Dr. Rafael Fasel, of the book Animals and the Constitution, and editor, also with Dr. Rafael Fasel, of the book Fundamental Rights for Non-Humans. So I'm very happy to welcome all three of you. Today's roundtable will be structured as follows. We'll first begin with a round of questions to the panelists directly, and after that, I will open the floor to you all to ask all the pressing questions that you will have gathered by then. So let's begin with a bit of a broad question to all of you to set the stage for the conversation. What inspired you to explore this concept of non-human rights, and how do you see this academic field evolving over the next decades? John, maybe you can start.
Yes, of course, and thank you, Eva, for chairing, and thank you for everyone that is joining us. So my interest in non-human rights starts with a interest in a more particular field, that is my interest in animal rights. And I've been working by myself and together with Dr. Rafael Fasel of the University of Cambridge on the constitutional theory and animals, including how animals should be represented in constitutions, and the constitutional recognition of the inherent value of animals. But from there, it was a short walk to considering the rights, the fundamental rights of also other non-human beings, of other non-humans, such as AI, artificial intelligence, and more closer to my own interest, rights of nature, because there seems to be a trend, especially in Latin America, of recognizing of protecting animals through the rights of nature. So this was a very easy step. AI rights, I'm just interested generally in the idea of fundamental rights and the extension to non-humans. So it was very easy to incorporate this interest into my existing existing research. And as you already said, Eva, together with Dr. Fazel, I'm co-editing this volume on fundamental rights for non-humans, and my predecessors in this room, Cesar and Alexis, have also published edited volume on this topic. And I think that together, of course, others are doing the same, but together we are really charting a new field of academic inquiry, which is that on fundamental rights for non-humans. And I think it's a very promising field, and I can't wait to see how it develops.
Thanks, John. Alexis, how's it for you?
Yes, thank you, Eva. So in my case, it was a mix of things, I guess. On the one hand, this phenomenon first caught my attention back in 2016 when an orangutan was granted legal personhood following an habeas corpus petition to a criminal court in Argentina. I'm originally from Argentina. So this was the first time a court of justice had recognized no human legal personhood to a no human animal. And the case is also particularly interesting because it eventually led to the permanent closure of the zoo, which was also the oldest and largest zoo in the country. So it really, rattled the cage, to borrow the title of a very well-known book. Has the power to transform persons into things, as in the case of slavery, for example, but also to turn things or non-humans into persons, like in the case that I just mentioned. So aside from this, biographical dimension, I think that what brought me to the topic, to this topic in particular, was its potential to radically reframe the foundations of our legal systems, so it opens the space to rethink answers for fundamental questions. So, for example, what is a legal person? What counts as a thing? What is the true potential of rights? And how do, for example, I don't know, legal institutions reflect, reproduce, or challenge our deepest ontological and epistemological assumptions? So these are not merely theoretical questions or inquiries. They cut to the heart of how we actually structure the world through the law, how the law actually performs the world in which we are living. As for the evolution of the field, this is a tricky question, I must say, because partly because there are different aspects to this question. So on the one hand, if you look at the cases where no humans have been recognized as right holders, either through legislation or judicial decisions, and you could check for this the recently launched No Human Rights database that you will find in the webpage of the Forum on the Center in the Human. So if you check these cases or this database, you will see that the recognition of rights to non-humans have exponentially grown year by year since 2008, when Ecuador first granted rights to nature in its constitution. However, this growth has been uneven. Interestingly, it has been easier for humans to grant rights to nature than to animals, for example. And the recognition of AI rights is still in its very early stages. But in terms of the academic field, we can see an immense growth over the past 3 or 4 years, especially in the areas of rights for nature and machine rights. That said, non-human rights as a field of inquiry, the field that, as Sean mentioned, we are trying to, in a way, to push forward, is still very much in the making. As I mentioned in the introduction to my book, animal rights, rights of nature, and machine rights have typically been studied in isolation rather than as part of a kind of broader interconnected, field or phenomenon. One of the key actually aims of my book is to show that these strands are actually part of the same phenomenon, that they share discursive strategies, justifications, and also confront similar challenges and have similar aspirations. So I believe that as climate change intensifies and as AI continues to evolve, this field will also grow significantly, and non-human rights will be, increasingly be understood and seen as a collective response to, this kind of, to the global crisis, the global environmental crisis, but also to the new emergent technologies that we are, seeing today.
Thanks, Alexis. Interesting that your interest was sparked initially through the case of animal rights. Cesar, how is that for you? Was it also the entrance to the field?
Yeah, thank you, Eva. I came to this field from a different angle. It was a combination of indigenous people's rights and generic human rights scholarship and advocacy. And it took me a while to catch up with these ideas coming from the human rights anthropocentric world. I had been exposed early on to the idea, partly because I've worked in Ecuador for 2 decades now. And I remember being in the Sarayaku indigenous territory in the Amazon in the early 2010s, speaking to the political and spiritual leader of the Sarayaku people, Don Sabino, and him telling me literally like to look around and say like everything is alive, all these trees and the mountains are alive, and they should be consulted as much as we are demanded that we, the human beings in this community, be consulted before all drilling proceeds, if it at all proceeds in this territory. So for those of you who have some background in indigenous people's rights law, the Sarayaku one, what I and many others consider the most important international court decision on indigenous people's rights, handed down by the Inter-American Court of Human Rights in 2012, acknowledging the right of the Sarayaku to FPIC, to free, private, informed consultation and consent. But I do have to say that even though at the time Ecuador already had rights of nature language in its constitution from 2008, I found the idea provoking and puzzling. But because I was working very much with human communities in places like Colombia or South Africa or India or Ecuador, I didn't know what to do with the idea and didn't know how to turn it into actionable propositions. And that actually happened also in Ecuador. For a while, the constitutional court was relatively passive in implementing the very idea. And in terms of how the field evolved and how I myself kind of evolved with the field, I think that there was a turning point towards the mid-2015, so the second half of the last decade, where, as John and Alexis mentioned, more and more scholars became interested in the idea. More and more cases were litigated and declarations were drafted and initiatives were pursued that enshrined the rights of animals, the rights of nature more broadly. For those of you who follow the case law, and we have done some of that work as well, but not nearly as systematically as Alexis and the Eco Jurisprudence Monitor website and other websites. You will know that most of the existing litigation has had to do with rights of rivers as opposed to rights of individual animals or species. The turning point for me, and with this I'll end, came right after the pandemic, or before. I should have mentioned an antecedent. What I've always done is action research. So I am based in academia, but my type of academic work is very informed by field work with communities on the ground. And I was involved in 2017, 2018 in a case representing young people to demand more climate action by the Colombian government. And that successful litigation led to a ruling by the Supreme Court of Colombia that, among other things, declared the Amazon as a subject of rights. That was not the main petition, but it came in kind of late in the process. But then many people became interested in that part of the decision, and I myself, kind of after the pandemic, started working more systematically on the theory and the legal practice of rights of nature, which led to the establishment of the More Than Human Rights Collective about 3 years ago when I moved to NYU. And I'll just say that I agree with John and Alexis that this is a moment. I remember when we first shared the invitation for scientists and journalists and indigenous leaders and legal scholars. MOTH is highly interdisciplinary, so perhaps we'll have a chance to have a conversation about different approaches to the field. But the first line of the invitation was that the rights of nature is an idea whose time has come. So I, with kind of a sociology of science hat, I thought that it was time to help and join those who were already trying to move this idea from the periphery to the mainstream, both in academia and in practice.
Okay, thanks, Cesar, for this explanation. In your edited volume, you also refer to this broader concept of earthly flourishing. Can you elaborate a bit more on how the concept of non-human rights contributes to this broader vision, and how it then also intersects with other topics such as climate change and environmental law?
Yes, so two things about that. One is that the way that I understand More Than Human Rights, and this is partly, it's not wanting to claim kind of ownership over a new term, which is something that we scholars do all the time. Like I'm very comfortable with the rights of nature terminology, but the reason why I wanted to add the More Than Human Rights term to the mix is twofold. One has to do with your question, which is that coming from a human rights perspective to the field of environmental law and then later to the field of rights of nature, I was already wary of the reliance on rights talk as a way to engage with big questions of, for example, earthly flourishing, right? So Catherine Sicking, who teaches at Harvard and is very well known social scientist working on the human rights movement, she published a fantastic short book whose title is The Hidden Face of Rights, which is all about duties, human duties, which is for those of you who come from that background, that the idea of duties was very much there in the original version of the Human Rights Project after the Second World War. The American, meaning the Pan American Convention of Human Rights, was called the Declaration on the Rights and Duties of, unfortunately, only men, but it was a product of its time. But the duties part is something that has fallen off kind of the radar, especially in traditions like the US, where the strong emphasis is on individual entitlements without regard or without equal regard to what that means in terms of responsibilities. So the earthly flourishing goal tries to recover kind of and to advocate for a more expansive understanding of what the More Than Human Rights Project means. And it means discussing responsibilities, discussing reciprocity as values that need to be incorporated into an ecocentric or more holistic, more earthly approach to the law, in which rights is one very generative concept, but it's not a concept that exhausts the possibilities. We're working on a number of legal actions, for instance, that do not center rights, but rather responsibilities and ways of thinking about how to reciprocate nature for what nature offers to humans. So the More Than Human Rights terminology also is meant to connote the idea that we need more than rights.
Thanks, Cesar, for that very clear explanation. So essentially, you see how this notion of earthly flourishing also opens up important connections beyond just law. And Alexis, you also approach non-human rights from quite an interdisciplinary perspective, combining also law with anthropology, philosophy. So how do you see these diverse perspectives helping to reshape the legal frameworks which currently largely exclude non-human entities from rights holding?
Yeah, I think that, coming at this subject from various different disciplines, at least in my case, has helped me to approach the issue from different angles. So, of course, there are clearly deep philosophical questions involved in the discussion of non-human rights, questions like what is a subject, how do we come to recognize someone or something as morally worthy or as a subject of rights. But for example, anthropology in particular has helped me to denaturalize how we ask and answer these questions. So it shows that other cultures or other people not only provide different answers, but also often start from entirely different questions. So, for instance, in the Western tradition, what sets humans apart from non-humans is often thought to be some sort of some kind of interiority, whether that's the soul in some traditions, rationality, or maybe sentience. But for many other people around the world, it's quite the opposite. The distinction lies not in the inside, but in the outside, in the body. In how we distinguish entities because or through their bodies. So human bodies are not like, say, the body of a river or the body of a shower. So, the kinds of questions these people ask and the kind of boundaries they draw are completely different. So there is a striking and quite funny anecdote that Lévi-Strauss, a French anthropologist, shares in one of his books. And he recalls that shortly after the so-called discovery of the Americas, the Spanish crown sent some sort of investigative commissions to the Antilles to determine whether indigenous peoples had souls. And this was something very important to them. This was a very important theological and legal question at the time because it was related to the issue of the possibility of owning property, right, and being considered persons. So, they were very worried about this, and also jurists and theologians were very worried about this, of determining whether indigenous people had souls, if they, in this sense, resemble European people. But as Lévi-Strauss also notes in this book, it seems that the indigenous people were also conducting their own experiments at the same time. So according to him, some groups of indigenous peoples would immerse Spanish prisoners in rivers for extended periods of time just to see if their bodies decompose. In other words, they were trying to figure out whether the Spaniards, whether the Europeans had bodies like them. So the questions are, you start from a different starting point, from a different perspective. So let me say also something very shortly about the critical perspective, because I think it's important. It's important in my work, but also it's important when you have like very novel topics like this. I think it's important we remain critical, though of course not dismissive of this phenomenon. Even if we can be sympathetic to the goals of non-human rights, we need to approach them with a healthy dose of skepticism as well. The rhetoric of rights has often been deeply paradoxical in its outcomes, even for humans. So we should be cautious about its prospects for humans for non-humans when they are extended to non-humans. Let's not forget that the age of human rights has also been the age of genocide, exploitation, ecological devastation. So my colleagues might disagree with me, I don't know, but I believe that human rights have largely failed to deliver on their promises, and in many instances, they have been part of a problem rather than the solution. So that's why I'm a bit worried of the growing number of celebratory or accounts of non-human rights, especially the accounts that call this phenomenon a revolutionary phenomenon. For example, because when you look at the actual implementation of these rights in places like Ecuador, in places like New Zealand, it's hard to remain, overly optimistic. You can be optimistic, but it's difficult, to say that, this is really a big revolution. Let's very briefly, let's take what is often seen as the most successful model, the New Zealand model. The country, New Zealand is widely praised from granting legal personhood to the Wanganui River. But if you actually read, the Wanganui Settlement Act carefully, which people, rarely do, but, we are lawyers, so we should do that. And, you see that while the river is recognized as a legal person, supposedly in line with Maori cosmology, the riverbed, the soil of the river, where mineral resources are found, remains the property of the crown. So, these are the kinds of paradoxes that often, we can see in non-human rights. So, yes, there is a lot of potential, but we also need to be cautious, critical, and clear-eyed about the limitations and also contradictions embedded in this framework.
Thanks, Alexis, for this critical reflection. John, you approach the topic from yet another angle, the constitutional lens, and you look at the intersection of animal rights and constitutional law. So how do you see that constitutional frameworks could adapt to recognize rights of non-human entities, and what challenges are there in this regard?
Yeah, thank you, Eva. I can see that my colleagues, both Alexis and Cesar, are maybe more pessimistic about this growing development of rights. Maybe Alexis in particular. And of course, I recognize that rights is not always the framework that can save us from ourselves. And that there are, of course, many problems with the rights paradigm, especially when the rights paradigm is a byproduct of another paradigm, which is the liberal paradigm. Okay, and I tend to work within that tradition. I'm a firm believer in liberalism, and despite acknowledging its limitations, its historical roots in genocidal, colonial mindset and practices. Nevertheless, I think there is a emancipatory power in liberalism and some of its constitutive parts, including rights. So as part of this liberal framework, there's also this paradigm of constitutionalism, which seeks to limit or shape the way in which governmental power is supposed to be used. I say not just limit, but shape, because of course there are constitutions empower public bodies to do things. They don't just limit them. And so within this liberal framework, which is indebted to, which is not indebted, but is positive about liberal ideas like constitutionalism, rule of law, etc., etc. My main question has been, okay, can we use this paradigm, this liberal paradigm, this rights paradigm for animals as well? Of course, rights are not the solution for everything, but they are an important tool in our vocabulary, especially in the Western vocabulary within which we or I work. The rights are not just a polemical force, but also a quite pragmatic one. We go to court and we seek to enforce our rights. And so there is a emancipatory potential in this language of rights. And yes, of course, there are many problems with this, as Alexis' work and I'm sure Cesar's work also shows. However, this is what we have right now. This is the instrument we work with. So let's see to what extent this can help animals. And so in my work by myself, but also work with Dr. Rafael Fazel, the question is, well, if constitutionalism can be a force for humans, a force for good for humans, why can't it be also a force for good for non-humans? My focus, of course, is on animals. And so my question is, well, constitutions actually impact the way in which animals live and in which they interact with humans. And it seems to me that animals are not just constitutional objects, that is the object of regulations by constitutions, though sometimes they are, but really they are constitutional subjects. That is, they are potentially beneficiaries of rights and entitlements and constitutional protection more generally. So the question has been, well, if this is the case, how should we rethink constitutionalism, especially the principles of constitutionalism like the rule of law, democracy, rights, constitutional rights, and principle of proportionality. And so my work, my recent work has been to rethink these principles from a less anthropocentric perspective in a way that really pays due regards to the inherent value of animals. And I hope to be able to continue this research agenda in the near future.
Thanks, John. What I think is intriguing is that all three of you in some way refer to rights also as a tool, a kind of a tool to empower certain groups. And I'm wondering, isn't there surely also an ethical component to granting rights to other entities? So what do you think are the main ethical considerations, and particularly in terms of potential conflicts with human interests and human rights? Perhaps, Cesar, you could start?
Sure. So just to answer the question, but also go back to this kind of evolving conversation and things that both John and Alexis have shared in this session. The short answer is that lawyers, constitutional lawyers, and constitutional scholars and human rights researchers and actors are very comfortable with balancing tests, right? Because this is what courts do all the time. This is what policymakers do all the time. This is what advocates need to do all the time. Try to weigh on a scale different considerations, be it across kind of human communities or individuals, or across the human and non-human divide. So I don't think that we need to reinvent the wheel and say, like, because now we're taking into account the interest and the intrinsic moral value of animals or forests or rivers or fungi or plants, this is going to be a completely impossible task. It becomes more complex, and people like John will have to do a lot of conceptual work, because of course if and we all, like I work with the human rights intellectual apparatus and constitutional law apparatus, and also I'm trying to bring that together with indigenous legal systems and worldviews, and that matching is quite complicated from a conceptual and a practical perspective. But in any of those frameworks, there will be conflicts among the rights of human beings, or different human beings, or different human groups. And to add to that complex picture, we would need to learn to better balance the interests and the concerns of non-humans. The legal mainstream has been able to completely kind of dodge the question by saying, like, there's nothing we should be concerned about when it comes to non-humans. Let's just focus on how to balance the interests of human beings, because that's complex enough. And that, I think that to all of us here and to many other people, is no longer tenable. And the question is how, but again, because we don't have too much time, I would say that I think that the technical tools and the conceptual tools that have been developed to deal with the clashes among human rights can be, mutatis mutandi, applied to the balancing of interests across the human and non-human divide. Then the question of whether the use of rights may end up being counterproductive for the purposes of protecting those groups of and species of animals or whole ecosystems. It's an important one. This is where, and I really am for cross-fertilization across intellectual traditions and fields of inquiry. This is where the debate on human rights that has happened over the last 10 years or so comes in handy, and I think that Alexis was referencing some of it, and John was also indirectly. There are different views of about the net impact of the human rights project, so to speak. And I know that in some quarters in global North academia, especially certainly my own kind of ecosystem here in the US, but I know that in the UK that has also been a very debate that is very alive with all this talk about the end times of human rights. I've written extensively about and against that view in Open World Rights and other outlets, and we also actually had a really good discussion here at NYU a couple of years ago when we held a conference on the future of rights and governance, and Catherine Sikin was part of that conversation. And what I would take from that, lift up from that conversation and that very generative debate between people who have different views on the human rights project is that whenever we compare, whenever we assess the contributions or the harms stemming from any intellectual and legal tradition, to me it's important to compare to the real as opposed to the ideal, because always, and this is kind of the sociologist in me trying to gauge what the alternative would be in real life. So if, for example, going forward, if we don't use the rights framework, I wanna have a discussion about what alternative frameworks would do more good for the animals and for the or for the non-human species, as opposed to discounting the application of rights, which, as you know from my previous response, I also have kind of doubts about, but the doubts do not amount to a wholesale rejection of the potential of that tradition for dealing with very pressing ecological challenges, from climate to biodiversity to toxic pollution and so on. I'll end by saying, and I imagine that we're going to have hopefully time for some of this in the Q&A. We may also have different views on how readily the concepts like non-human rights or more than human rights can be extrapolated from organic forms of life to synthetic forms of life. The moth framework was developed to deal with the protection of animals, plants, fungi, forests, rivers. I sympathize with the conceptual complex exercise of thinking of about future entities that may be aware, may be conscious, may be even sentient. But I would like to pause. I would like to take a pause before taking that leap, because again, and this is a sociological skepticism. I think the political economy of those two worlds is very different. It's one thing to advocate for the health of the remaining forest, and it's another thing to advocate for the rights of synthetic entities that are being actively pushed forward by some of the most powerful people in the world. So I wanna add, I hope to have future iterations of this conversation, and with people in this panel and other people, I wanna add kind of a note of sociological skepticism about the leap from rights of nature to the rights of synthetic forms of life.
Thanks, Cesar. Perhaps Alexis or John could very shortly comment on this. I would like to also have some time left for the Q&A.
I can maybe say something, because, precisely in this issue of the balancing, or in this issue of the conflicts, I think that you can see some of the limitations of extending rights to non-humans. First of all, and this is the problem with one of the problems with rights. Rights introduce an adversarial dimension into the human, in the human-human relation, but now into the human-non-human relationship framework of, into that space. And this is something that rights produce. It's not necessary to think about the relationship between humans and non-humans in these adversarial and conflictual terms. But once you introduce rights, you start thinking that way, and then you have conflicts of rights, right? So as Cesar said very well, judges are very used to deal with these kind of conflicts, especially, trying to balance in or to harmonize different conflicts, but not always it's possible to harmonize conflicts. And in fact, you have some scholarship saying that the very notion of balancing and harmonization actually mask what is essentially sometimes the prioritization to prioritize one of the interests over another. So, and we have seen this in the case law. It's not something new. So it would probably happen as well in the case of non-human rights. So the real question is, in a real conflict, what will we prioritize? If forced to choose, for example, do we save human lives or do we save animal lives? These kinds of dilemmas, expose the limits, I think, of the framework, no human rights framework. As you probably know, Tom Regan, a philosopher known for his very strong defense of animal rights, famously, has engaged in this dilemma with the lifeboat scenario, which is a kind of hypothetical setting where you must choose whom to save if a boat is sinking and you cannot carry everyone. And as you probably know, Regan, who was one of the first advocates of rights for animals, along with Peter Singer and others, despite his deep commitment to animal rights, concedes that in such cases, in such tragical cases, he says, it is morally permissible to save the human over the animal. So these kinds of limit cases, I think, underscore some of the tensions, in the non-human rights framework. So on another note, it's and this is partially related to what Cesar said, which is, I totally agree with this. There is an issue with thinking extending rights to nature or animals along the same lines of extending rights to AI, for example. Because it's easy to think about conflicts of rights between, nature and animals, for example. So of course, like humans, animals have a significant environmental impact. Cows farting is a very good example, an example that we all know. But what is less frequently acknowledged is that AI rights could also, be in sharp contradiction with both animal rights and the rights of nature. As we know, the material infrastructure of AI is highly dependent on natural resources and it's extremely energy intensive. So some people actually argue that AI is currently works as a kind of extractivist technology, one that contributes to environmental degradation on a super massive scale. So in this context, recognizing rights to AI, for example, the right to life, could run, counter to efforts to protect the environment and to uphold the rights of nature. So you see all these tensions and contradictions, and I think in this issue of conflicts and balancing, you can see some of the limitations of this framework.
Okay, thanks very much for this very thought-provoking ending debate. We will now have some 15 minutes left to answer questions from the audience. So feel free to either raise your hand and I'll give you the floor, or put your question directly in the chat. I quickly saw a raised hand appearing, but it has disappeared again. I'll give you a minute.
Perhaps while we wait for the next question from our audience, I can chirp in
Yes.
30 seconds or so. I think both Alexis and Cesar show very good reasons to be skeptical of let's say AI rights. But my skepticism tends to run the other way. I'm quite skeptical actually of the rights of nature movement, more than I am of possible extension of rights to AI, artificial intelligence, or to in fact animals. And I think my skepticism runs because it is hard. My criteria for moral personhood or moral consideration is in fact sentience, and it's hard to determine, at least on the typical Western cosmology, or secular, I should say, on a typical Western secular cosmology, that elements of nature are sentient, and so it's hard for me then to extend this framework of rights to elements of nature that are not sentient. Of course, elements of nature that are sentient, like animals, yes, of course, but rivers, mountains, forests, as a whole, rather than their component parts, I am more skeptical. Of course, we don't have sentient AI, so far as I know at the moment, but should such develop, notwithstanding the words of caution by both Cesar and Alexis, I think I'll be more sympathetic to such an extension. But I see that an hand has been raised, so I will stop.
Yes, we have a question by Liliana Mosquera. Perhaps you could ask the question by unmuting yourself.
Thank you, Eva.
Great.
Good afternoon. I just have this question regarding to the debate with the other experts of the other part, which is nature. For me, it's very hard to find the debate between or among the biologists or ecologists where they are saying about this, because of course the extensive literature among philosophers and of course all the lawyers is growing a lot. But if for my research, it's been very hard for me to find which ones are the position of the other part of the experts. We are the biologists, ecologists, I don't know, geologists, all this group of experts. What is your opinion on why these people is not responding to this framework? Thank you.
Anyone who would like to answer this?
I'll take a stab at it quickly, just because I've had a very different experience in the Moth Collective. I actually some of the founding members of the Moth Collective are botanists, mycologists, ethologists, and I've found myself playing catch up with them in terms of the boldness of the proposition to protect more than human entities, organic human entities, plants, fungi, animals, as subjects of rights. And this is why the Moth Collective, many of the legal actions and the research projects that we undertake are done in collaboration with marine biologists and ecologists and botanists and mycologists. And in fact, some of them, if I don't know, probably many of you are based in the UK or even London, we're going to run a whole program in late June with some of these biologists. We're going to teach a 1-week course at NYU London with Merlin Sheldrake and Rob McFarlane and other colleagues who have joined the debate very enthusiastically, not always, of course, supporting every argument for the rights of any particular non-human entity, but with some of them, for example, we worked on the implementation of the Los Cedros court ruling in Ecuador, which protects the forest as a subject of rights. And the reason why this is happening, I think, in addition to them being very open to interdisciplinary engagements, is because the findings from quote unquote hard science are challenging the conventional criteria that have been used to tell apart humans from non-humans. Just to give one example from the work that we're conducting, we work with Project SETI, Citation Translation Initiative, which is the collective of AI scientists, marine biologists, complex science experts who are farthest along in understanding the complexity and potentially decoding the content of whale language, sperm whale language. You may have seen this work covered in the news. And as they've made progress by leaps and bounds, recently published a paper in Nature Communications, the conventional kind of reservations about extending rights to animals, and let's stay with animals for now. For example, them not having not only sentience, I'm not a scientist, so to speak, but also intelligence, awareness, consciousness, and even language have also been quite actively debated in biology, in ethology, and also more recently in linguistics. And so that all of that energy coming from the hard sciences and the further questioning of the separation between human capabilities and non-human capabilities has provided an impetus for some of the work that I and others are doing in the realm of law and moral theory.
Okay, thanks, Cesar. We have another question. Begonia, can you ask your question? Panelists.
Yeah, sorry, now I am. Okay, first of all, thank you for this interesting dialogue, and glad to once again Professor Cesar and Alexis too. And well, I was thinking about the complication about the creative entities at this moment with this false creation of the extinct species, like those wargo wolves. And how could we think about the complexity of rights that are there? For example, the rights of those objects, they are made as objects, but they are subjects. They could be subjects of rights, but also the rights that could be in relation with the ecosystems. They could be that there are around those new species introduced, and the rise of related species of other wolves that may be close also geographically to this species. So how could we think about the complexity of legislation or rights that could be in conflict with these species, with these new species? Thank you.
Okay, who would like to answer this question?
Okay, I guess that falls to me then. If I understood your question, well, please correct me if I don't. It seems to raise a old debate between individualistic approach to protecting, say, animals and a ecological approach to protecting them, whether we protect independently of the fact that this some of these species have been reintroduced through cloning or artificial means. Nevertheless, it can be that you know, we have to take a more ecological view of protection of these species. So we protect. We may want to protect the species as a whole, and sometimes that may actually entail destroying or killing some of the individuals that belong to the species, maybe because there's problems with overpopulation, etc., etc. I'm quite wary of this. If I well understand your question, I'm quite wary of the framing of that question or as a conflict, because it I think it hides that the problem, especially in the case of cloning or bringing certain species, recreating certain species, is a problem that starts from the human. It's human that have created that problem in the first place for their own anthropocentric needs. And then there is this afterthought of how do we manage this problem that we have created in the first place. So I would like to think that maybe it's possible for us to be a bit more humble when we engage in this kind of experiments of reintroducing species that have gone extinct for whatever reason, and that perhaps we should pause before we take such short steps. This case also when it comes to so-called invasive species, that is animals that have been introduced in their non-natural habitats, and then they cause a problem for the existing animals or plants or ecosystems in which they are introduced. And we ask, oh, what should we do? Should we cull this invasive species, which is usually yes, or should we find some other solution? I want to question the framework. Is we created the problem, and by we I mean the humans, by introducing these species where they didn't belong in the first place. So it's just this request for humility, I think, can help us in solving some of this, and making sure that these problems don't arise in the first place.
Okay, thanks very much, John. Just to end, a very short question that was put in the chat by Victoria Cavuto, who says, thank you for the insightful debate. Would any one of you think that if non-human rights were to be recognized in law, they would strengthen human rights? And if so, why? Perhaps Alexis, can you answer this?
Yeah, I can try. I would like to actually reframe the question. I would say, I don't know if they can strengthen human rights, but I'm interested in the question whether non-human rights actually, strengthen the idea of the human, actually, if they are actually at the center of the human or not. So, I'm bringing the question to some of my interests. Sorry about that, but I think partially will answer your question. So I think one of the problems with non-human rights is that to base the decision of extending rights to animals, nature, air, or whatever, we are using a completely anthropocentric criteria, which is to say, well, humans are the standard to think about this. So if animals, rivers, machines are either intelligent, sentient, ancient, or any other category that humans actually possess, we should thinking about extending rights to these beings. So, this is, I think, a deeply problematic way of justifying the extension of rights to non-humans, because, as I said, it positions the human as the standard and measure of all moral worth. Recognition is granted not on the basis of what non-humans are in themselves, but on how closely they approximate a human ideal, whether that ideal is based on intelligence, sentiency, agency, and so on. So I believe, far from the center in the human, this framework tends to reinforce, anthropocentrism. So it doesn't challenge the human's privileged place in the legal and moral order. It actually confirms it, through a complicated and intricate way, because it's a kind of decentering to reach a new decentering in which some of the human traits, some of the most well-known human traits, are placed as the main criteria to decide whether other beings are morally worthy or not. So if they strengthen human rights or not, I'm not sure, but I'm sure that in some way, and of course, I'm generalizing here. I don't want to speak, the non-human rights movement, it's very broad. And you have many different positions over there. Actually, some of them are, contrary to each other. But speaking about the mainstream, the biggest part of the movement, or the most visible part of the movement, I think even if they have really great and good intentions that we can share, even if they want to decenter the human or to, you know, get some sort of non-anthropocentric law, you know, basing the criteria on this idea in which the human is placed as a measure actually achieves the opposite.
Okay, thanks very much. I think that's a wonderful ending reflection to end the meeting with. We're a bit over time. So I'd like to thank you, all of you, and especially our panelists and the audience for this truly stimulating discussion. And I think the questions we explored really highlight how complex and urgent the topic of non-human rights has become. So Ram, thank you again. And I hope this conversation also contributes to ongoing reflections and collaborations in this field. I wish you a very good afternoon. Thanks.
Thank you all, and thank you, Eva, for sharing.
Yeah,
Thank you, Eva, Sean,
now.
Cesar.
ciao.
Bye-bye.
Bye now.